first matter to come before the board this morning is Village of Boston Heights versus Eric Brewer. This matter was set to begin at 11 o'clock. It's my understanding, and it is now 11:14. It is my understanding that Mr. Brewer has called us and let us know that he will not be in attendance today. So council, on behalf of Village of Boston Heights, you have 15 minutes with which to present oral arguments.
Thank you, Your Honor. Morning. May it please the court, my name is Thomas Staccato, and I'm here on behalf of the state of Ohio and the Village of Boston Heights. This matter took place on October 23rd, 2015. The appellant, Eric Brewer, was operating a motor vehicle in the Village of Boston Heights in Summit County, Ohio. He was under suspension at the time. He was stopped by a Boston Heights police officer who ran his license plate and found that he was suspended. And during an inventory search of his vehicle prior to it being towed, a container of marijuana was found in a pill bottle with Mr. Brewer's name on it. He was charged with driving under suspension, the unclassified misdemeanor, and possession of marijuana, a minor misdemeanor. Neither of these offenses carries any potential jail time. As the case, and by the way, I think I should point out in the numerous things that Mr. Brewer filed in all of this case, there has been no dispute that he was operating a motor vehicle, that he was suspended at the time, but that there was marijuana in the vehicle. While the case was pending, Mr. Brewer elected, despite being given an opportunity to hire an attorney, he elected to proceed and represent himself, and he filed a large number of pleadings in the trial court. They addressed a number of different issues. Most of them did not comply with any pleadings acceptable under the criminal rules, but in the interest of justice and to give him his fair day in court, they were all addressed by the trial court. The court elected to have a hearing where discovery issues were discussed, and then there was an evidentiary hearing held where Mr. Brewer would have a chance to present his arguments to the court, cite any law that he felt was appropriate, and present any evidence he had. The state was given a chance to respond.
I mean, were any of those motions a motion to suppress, or did the court interpret any of his motions as a motion to suppress?
He did not file a motion to suppress, but the court did address issues that had something to do with suppression issues that he raised. He filed a motion to eliminate, and he filed some discovery, and he titled them a lot of different things. But the court did address everything that he filed and kind of took them, tried to sort through them and address them in the best way possible, because, again, he was pro se, and the trial court wanted to make sure that he got a fair hearing on everything. So the court held a hearing, addressed every issue that Mr. Brewer had filed, and subsequently all of his motions were basically overruled or resolved at that hearing. And Mr. Brewer has failed to obtain a transcript of that hearing, and it's the state's position that this court would be unable to review and should affirm those decisions because he has failed to provide you what the judge heard from Mr. Brewer, from the state, and basis for her ruling. Subsequent to that hearing, a trial was held. Again, it was a very long trial for a trial to the court on a driving under suspension case, but Mr. Brewer was given a full opportunity to hire counsel before that. He elected to proceed on his own. He renewed some motions, and he had an opportunity to hear the evidence presented, to cross-examine witnesses, and all the basic trial rights. He was found guilty of the two offenses for which he was charged at the conclusion of that trial. He has raised some issues in his appeal, again, regarding that trial, as well as the hearing and the other ruling by the trial court, but has failed to provide this court with a transcript of those proceedings. So since there's really, in effect, not a complete record for this court to review, I would ask you to affirm the conviction for these two charges. And unless the court has any questions, that's the conclusion of my remarks.
I do have one just for clarification purposes. Way back to the beginning of your argument, you mentioned that one of the offenses was an unclassified misdemeanor and then said it didn't carry jail time. I want to make sure that we're on the same page. That's pursuant to the Boston Heights statute, correct? Not just because it's an unclassified misdemeanor.
Yes, Your Honor. And it's mirroring a state code that is an unclassified misdemeanor, the driving under suspension. So that was addressed at the trial court, that he is not under any jeopardy of jail if he's, from these offenses. And the penalties were explained to him in the trial court as well.
Thank you, counsel.
Thank you.
Court will take the matter under advisement. We will issue a written decision which will be mailed to both sides as well as posted on the Ohio